Well, hello and welcome to this edition of Live Legal Q&A. This is our second episode that we're doing, Live Legal Q&A. For those of you who don't know, I'm Peter Lamont. I am a business and personal law attorney. I'm the principal of the law offices of Peter J. Lamont, and we provide this service as well as some of our others, like our radio show over at utlradio.com, and our Facebook page, our blog, as a service really to the community, because I think it's really, really important that you guys out there understand your rights and obligations under the law. It's so important because, you know, we have all heard that old adage that ignorance of the law is not a defense. But beyond that, it's really important for you guys to understand what your rights are, and I know how difficult it is to go out and ask an attorney a question and, you know, try to get an answer without having to spend a lot of money. So that's why we're doing this. This is the second week. Last week we sort of initiated this whole idea of a live Q&A. We got a lot of positive feedback, and I appreciate and thank you guys for contacting me and letting me know that this is something that you want to do and that you want to see. So I encourage you to not only listen to the questions that we're going to be answering today, and these questions are based off of questions that we received during the week, either through email or on our social media pages, but to you yourself ask a question. You can post it right on the comments below the video, or if you're watching this through a Google Hangout, you can leave the comments over on the side. But I encourage you to do it. Ask your question. You're going to get an answer today from me. And I'll do my best to get through as many questions as we can. So we're going to be doing this for the next hour or so. If we run out of questions, obviously we're going to end it a little bit shorter. But again, let me know what you guys think about this, if this is a good service, something that you'd like to see more of, and then continue to send in your questions. Obviously, you can tweet me at @PJLLaw. You can find us on Facebook. We're over at Google+, just search my name. You can also find us, obviously, on YouTube, since it's a YouTube live program. You can find us on YouTube. You can go to our website, which is my name, peterlamontesq.com, or you can look up our radio show, our radio podcast, which is Understanding the Law Radio, utlradio.com, and it will give you all the links necessary to listen to our live radio show, which airs Mondays and Thursdays. So enough about that. Why don't we get into the first question? So the first question here is whether or not the spouse of someone who has died. So, you know, obviously this woman has lost her husband, and what she wants to know is whether or not she is responsible for medical debt that is left over after insurance has paid what it would pay. So this woman's in New Jersey, and you know, it's an interesting question, and I think it's a question that we see quite often, because it's a question that sounds reasonable to assume that when an individual dies and he's got medical bills and there's no money in the estate, because that's what's happened here. There's no money in the estate. It's a husband who has died, and they live in an apartment, and they've got no assets. So there's nothing in the estate to transfer down to his surviving wife. So is she on the hook for the medical bills? You would think no, right? I mean, that's what most people think. That's the response and reaction that we get. Well, no, it's not her medical bill. Her husband, unfortunately, is deceased, so she shouldn't have to pay it. But in New Jersey, the law is that a surviving spouse is responsible for remaining medical bills once the other spouse has died. And that can be problematic for many, because depending upon the medical treatment that was involved, we could be talking about a bill of $500, or we could be talking about a bill of $50,000, depending upon surgery and that sort of thing. So the answer to the question is yes, but now let's just take that one step further. Well, what do you do about it? What do you do if you are left holding the bag with medical bills after your spouse has died, and there's no money in the estate to satisfy the the outstanding bills. Well, this is going to tie into another question, and the other question is, what is Chapter 7 bankruptcy? So these two questions are kind of interrelated. So let's use, for example, this idea of a spouse who is now stuck with medical bills left over from the deceased spouse's treatment. What can they do? Let's assume for a minute it's a $50,000 bill. Let's assume that the deceased spouse had a lot of surgery and numerous hospitals, and so we're looking at a very, very large bill, and that the surviving spouse has no money. Let's say, for example, she works at a low-paying job, and she has no house, no assets. Maybe she's got a used car that she's had for a long time. What does she do with this $50,000 bill, and what's going to happen to her? Well, the first thing that's going to happen to her is that the medical providers who are looking to recoup the money, they're at some point going to turn it over either to an attorney or a collection agency. And, the way that the world is and the capitalist society that we live in, they quite honestly don't care that you have no money or what your circumstances are. Every once in a while, you're going to find some individual who says, oh man, I really feel bad for this person, and they're going to do the right thing. But those people and those businesses are few and far between. What would happen is that it would be turned over, and within a relatively short period of time, the surviving spouse is going to get a letter or a lawsuit. Now, the surviving spouse can't pay it. What do you do? Well, if you do nothing, we talked about this last week, if you do nothing, you're going to have a judgment issued against you. And a judgment in most states, it does vary, so you're going to have to check your individual state's rule. In New Jersey, it's 20 years. So if you have a judgment, it can be enforced for a period of 20 years. And that's a long period of time, because you've got somebody who's tracking you down every few months to see if you have new assets or a better job. And if you do, then they put in an application to garnish your salary or levy your bank account. So it's a bad thing. Judgments are bad. The other option for somebody in the situation that I just laid out would be Chapter 7 bankruptcy. So what is it? Well, Chapter 7 bankruptcy is the liquidation bankruptcy. It's not a reorganization where you are keeping all the debt and you have to come up with a payment plan and the court's going to help you do that. This is a free and clear, I'm going to erase, to wipe out my debt and to get a fresh start. So while this question that it's out there, what is Chapter 7 bankruptcy, is simple to answer, I just told you what it is, there's a lot more to it, and I want to just take a minute to kind of go through some of that with you so you get a better understanding of it. So Chapter 7 bankruptcy, it is a way of erasing your debt. There are certain debt that can't be erased, and the technical term is called discharge. There's certain debt that can't be discharged. What is that debt? Well, tax liens, tax debt, federally insured student loans like Stafford loans, that sort of thing. You're not going to be able to go and discharge that debt. But what debt is dischargeable? Auto debt, right? If you have auto debt, lawsuits, judgments, could be credit card bills, could be medical bills, could be loans that you might owe to somebody that are not secured loans. So there's a wide array of financial matters that can be discharged in bankruptcy. And so when you discharge something in bankruptcy, you get a free, a chance to start again, or a fresh start. Not free, but fresh start. So in the case of the woman that we were describing, where she has no money and she's got this $50,000 judgment and she works at a very low-paying job, what can she do? Well, the answer is she should meet with an attorney and review what her finances are. Does she have any other money in savings? Let's assume no. And it's just a minimum wage job that she's got, and she's got $50,000 in debt. What does she do? Well, Chapter 7 bankruptcy would probably be the best solution for her. There's something called the means test, and that is really a debt-to-income ratio analysis that's performed to determine whether or not you qualify for bankruptcy. So in this case, I would venture to say that she's going to qualify, and it's really sort of location specific because certain counties throughout the United States and different states are going to have different standards and requirements, and the average median income is going to be different, and so that affects the means calculation. But let's assume for a second that she qualifies for the means test. She can qualify for Chapter 7 bankruptcy. What does that mean? That means that once the bankruptcy petition is filed, the court issues an automatic stay. So now the medical company who is looking for that $50,000 bill can't sue her. And the debt, after a period of time and after certain hurdles are met, the debt will be wiped out and she won't be responsible for it. What we can do if you have additional questions about bankruptcy is we can do a show that's just about bankruptcy, and I can answer your bankruptcy questions because it's not so simple to understand. I gave you a really kind of dumbed down version so that we could just get through the question and to give you a basic understanding of what it is. But we can go through the various complexities of bankruptcy law and what would be discharged, what would not, how long it would take, what the costs are associated with it that most lawyers charge, how long it takes, what other things you have to do, credit counseling, is that required, all that sort of thing. So I'm going to wait and see what you guys say. If you think that it's worthwhile going through a bankruptcy sort of seminar, let me know, post your comments, and then we'll set something up and we will we'll talk about bankruptcy. All right, next question. This gentleman went on an airplane and they, surprise, surprise, lost his luggage. And he wants to know what he can do about suing the airlines for losing his luggage. Okay, well, this is a tough one because you're angry, you've lost your luggage. Hopefully there was nothing in the luggage that was super important. Maybe it's just clothes. Well, what do? You're angry and you want to sue. Well, we've got to go back to our analysis that we've talked about in some of the videos that we do, the instructional videos or the law basics videos. What are the components to a successful lawsuit? Well, A, you've got to have liability, and liability is who is at fault, who did something wrong. And B, you have to have damages. So, in this case, did somebody do something wrong? Well, clearly, because the guy's luggage is missing. So, liability should be 100% on the airlines. They are 100% liable for losing his luggage. Now, the second part of that is damages. Does he have damages? Well, the value of his luggage. Now, if he says, you know, I have a stack of $20,000 in cash in that suitcase and it's missing, he's going to have a tough time proving that $20,000 cash was in that suitcase. Generally, if you've ever lost luggage at an airline, they're going to ask you to fill out a claim form. They're going to want to know what was in that luggage. They're never going to believe that you had undocumented cash in your suitcase. So that's going to factor into what his damages are. Well, all right, so now we know there's liability and there's damages. Can he sue? The answer is yes, he can sue. Will it be worth his while? And that's where we have to debate. Is it worth your time and effort to file a lawsuit, to pursue an airline company in court for the value of your suitcase and lost belongings? Well, that's up to you. If you've lost clothes, which have very little value, unless there's some sort of designer clothing, you're on a photo shoot or something, you're a model and the clothes are worth a ton of money, that's a different story. But if you're like me, you know, my understanding the law polo shirt has no value to it. It's you know, just a shirt. So what are my damages? Well, what's the value of the luggage? How long have I had the luggage? Because that factors in. Is it luggage I just bought? Do I have a receipt? Can I show what it's worth? Because everything that you as a consumer buy I'm not talking about collectibles, but just as a consumer, a shirt, a piece of luggage, even your car, it depreciates in value from the minute you take possession of it. So if I paid $25 for my shirt, does it have a $25 value 6 months from now when I've washed it 100 times? No. So while you do have a case, in theory, is it worth pursuing it is the question you've got to ask yourself. You have to file the complaint, which costs money. You have to spend time drafting the complaint, which takes time. You have to serve the defendant, unless it's like a special civil court in New Jersey where the court will serve it for you. It's a lot of effort and a lot of time. At the end of the day, if your luggage and the value of your lost items is $200, you are going to spend far more time and money pursuing that claim than it's worth, in my opinion. And that's an analysis that we have to look at. We just got a question in response to what I'm talking about right now, and it says, yeah, but what about the principle of the thing? And that's an argument we hear all the time, right? I'm just telling you right now that I don't think that it's worth it for you to pursue a claim that has a very low dollar value, and you're going to have to spend more money than what you're going to get out of it. So if you're going to spend $300 to sue them for $200, that doesn't make good business sense. And the question that we just received is, well, what about the principle of the thing? And the answer to that is, that's a personal choice. I like to tell people to think with a business mind. Put the emotion aside, because emotion does not serve you in litigation. Emotion distracts you. Emotion clouds your judgment and makes you do things that are not strategically good for you. So what about the principle of the thing? Well, you tell me. Are you really going to punish the airline by spending $300, $400 to pursue the claim in the hopes of getting your two? Do they really care about your lawsuit? No. So principle of the thing, to me, isn't the decision that you want to base, or isn't the end result that you want to base your decision to pursue the airlines off of. I think it probably would save you money to maybe go to the airlines and complain. Maybe they'll give you a voucher. Maybe they'll give you something. And for your time, my time is more valuable, I guess is what I'm trying to say, than trying to pursue somebody where I'm going to spend more money than what I could potentially make, and that's not really a good idea. So have a claim, yes. Should you file that claim? That's up to you. I would say no, not for that dollar amount. All right. Next is divorce. Now, this is a popular one. We have a number of questions about divorce, and they primarily focus around the fact that when you're going through an issue with a spouse, the vast majority of us, it becomes a financial burden. You're trying to figure out where you're going to go, what you're going to do, how you're going to split things up, and unless you've got a lot of money sitting in the bank, it is extremely expensive to litigate a divorce case. Now, even if you get an attorney that has reasonable rates, I mean, we have reasonable rates, but does that mean that divorces are cheap? No. Well, why is that? Well, it's because of the other side. You might be completely reasonable. You might in your mind believe that you're giving the other side everything that they would like, and then they have an attorney whispering in their ear saying, well, that's not fair, and how about this, and what about that? So when you've got two people who are at odds, right, the husband and the wife, and then attorneys on either side, it can become quite contentious, and then you've got yourself a year-long legal battle, or 2 years, or a year and a half, or whatever it might be. So what's the solution to this? Because think about all that time that the attorneys are charging, even if they are really super low-rate attorneys, like a guy that just got out of law school or a girl that just got out of law school, and they're doing it for next to nothing. Well, 100 hours times next to nothing still adds up. So you have to keep that in mind. So what's the solution? How do we, solve this problem? Um, well, there's a couple ways, and it's funny because this question was asked, and while I was going through the list of questions for this live Q&A, I actually got a call from somebody who had a very similar question. I'm going to tell you what I told them. To litigate a divorce could be anywhere from, and this is low to super high spectrum, $5,000, which is low, and you're going to have that only in rare circumstances, all the way up to $50,000, $60,000, $75,000, $100,000, depending upon the size of what you guys have, your marital property, and how contentious you guys feel towards one another. So the way around litigation is mediation, and this is what I had suggested to the caller who called in not too long ago before I went on the air with this live show. Mediation is a sit down essentially between yourself, your wife, or your husband, and an impartial third party. We have at our office a certified family law mediator who sits down with the parties, and they go through the issue, and they try to resolve it in an amicable fashion. So the mediator's there. They're not representing the husband. They're not representing the wife. The mediator's there for both of you. And a mediation, if you guys can see eye to eye and work out something, is so much more affordable than divorce litigation. Any of you out there who have been through a divorce and it's involved attorneys, you know what I'm talking about. The fees are astronomical compared to mediation. I mean, there are mediations that are done for $1,000, $1,500, and you're done. You guys reach an agreement, settlement agreement is drawn up, and filed with the court, and before you know it, you're divorced. Unlike litigation. So mediation is a way to keep divorce costs down. It's also a way of streamlining the entire process, because when you file a complaint for a divorce, what are you ultimately hoping for? Well, you're hoping to get a judgment. You want to get out of this marriage, and you still have to go through that negotiation process of, well, this is yours and this is mine, and I'll see the kids on this holiday, and you take the kids to school, and what about medical care for the kids? Who decides that? You still have to deal with those issues. You just do so through the courts with attorneys who are charging you for every tick of that clock. So why not bypass that whole ordeal? Why not go and sit down with your spouse when you realize that there's a problem? And I understand that this doesn't happen with everybody. I understand that there are those people that you walk in on your husband and he's in bed with somebody else, and you don't want to work anything out. You're so mad, you're so hurt, you want to get a lawyer. I understand that. But in those cases where it's just not working out, you fell out of love with somebody, you just can't take their lifestyle, you're not happy, and you're just going to get a divorce, you guys really need to try to work together, because if you could just agree even on 40% of what's at stake. So for example, agree that you want to get divorced, agree that you want to move on, agree that you're going to do the fair and right thing for the kids, agree that you're going to split up a house or who gets a car. You're on your way. At that point, all you need is a mediator to sit down and help you go through it. There's a show, I think it's on Bravo, and it highlights a divorce attorney and mediation. And that show is television. While the clients are real and the scenarios are real, we're dealing with people that are fighting over a wooden statue of Buddha that they got on their trip to Malaysia, and silly stuff. I mean, we're not talking about that here. I'm talking about real world practical advice. Right? If you are going to get divorced, consider mediation first. It will save you tens of thousands of dollars, hours and hours of frustration, and you'll be done. So that's the answer to that question. How can you keep the cost down in a divorce? Well, look for mediation. All right, next. Do I need a real estate attorney? And that's a question that we see all the time. Do I need a real estate attorney? And I guess the next thing you're probably thinking, well, the question doesn't ask it, is, well, if so, why? All right, so selling property, clearly I don't have to tell you, it's one of the largest purchases that you're going to make in your life. Buying or selling property, real estate, is a complex transaction. Should you do it alone? No. Simple answer. Can you do it alone? Well, I assume you could probably muddle through it, but it's not a good idea, and there's a variety of reasons why. The number one reason why is if something goes wrong in the transaction and you are representing yourself, who are you going to blame? Who are you going to sue if there's a problem? Yourself? So see where I'm going with this? You should have a lawyer. You should have a lawyer because a lawyer is a professional who should have, if they're a real estate attorney, the requisite knowledge and skill in order to help you buy and sell real estate. If that attorney screws up, you've got recourse. You can go and you can sue that attorney. Maybe that attorney's committed malpractice. At least there's something for you to hang your hat on and try to collect your money or get some sort of other resolution. You do it yourself, you're going to be suing yourself, right? Probably not going to work out so great. So what does a real estate attorney do for you? The number one thing that they do right at the beginning of your negotiation or at the beginning of your transaction, right? You go in and you pay $1,000 deposit to your real estate broker, and then you sign the contract. Well, what happens next? Well, then there's an attorney review period. And that's the time when an attorney looks to see if the contract and the terms are fair for you. Most oftentimes, because they use stock contracts, and that's another question that we get all the time. Well, isn't it a stock real estate contract? Why do you need to negotiate it? It is a stock contract, but that stock contract doesn't work for everybody. Maybe your transaction's different. Maybe you need more time. Maybe there's more contingencies that you want to throw into the contract to protect you. You know, there's a ton of things that need to go into a contract that are not in the stock form contract that your real estate broker or agent gives you. So number one, the attorney is going to negotiate the contract. And in the attorney review period, depending upon your state, the majority of states, we're looking at 3 days. So a 3-day attorney review period, and after that attorney review period, you're deemed to have accepted the terms and conditions of the contract. So that's what they're going to do first. They're going to look at it, check and see if it's fair, and negotiate something that is fair for you. All right, now, once that's done, what do? Well, they help procure the title work. They help or work with you concerning the home inspection. Now, they don't do the home inspection, but they're going to work to look at the home inspection report, and they're going to say, all right, look, client, you had a home inspection on this property that you want to buy done, and look at all these issues that have been identified by your home inspector. Why don't we look for a credit from the seller? Because it's going to cost you, I don't know, $30,000 to make these repairs. Doesn't seem fair. Let's see if we can get a credit, or if we can get the current homeowner, the seller, to remedy these situations before you take possession of the property. So they'll do that. They'll also handle all of the paperwork associated with the closing, and believe me, there's a lot. When you actually go to the physical closing, you could see a stack of documents like this, and that's something that the attorney has prepared. And then, of course, they go to the closing, and they sit with you, and they sign all the right documents. They get you your keys, or if you're selling it, they give your keys away, and you're good to go. There are a lot of moving parts in a closing. It seems like a simple thing, but it's not. I don't remember the last time we had a simple closing. My real estate department has had crazy complex things arise, even on things that you thought were simple. We had one recently where it was a very straightforward looking closing. Nice residential house, very small. Everything was wrapped up with a bow. But then when the title work came in, it turned out that there was an issue with the deed, and a new deed had to be recorded, and it took it out of the realm of that simple closing. So in my world, in what we've seen, to say that a closing is simple, it's non-existent. There's no such thing as a simple closing. They all have their own issues. Don't do it yourself. You're not going to spend that much money. And that's another question that I might as well jump on, as long as we're talking about the money. What does it cost to hire a real estate attorney? And well, that depends. If you're in New York City, it could cost you $2,500 for a closing. If you're in New Jersey, depending upon your county and the value of your property and the complexity or perceived complexity or simplicity of your transaction, it could be anywhere from $900 to $1,500 to $1,700, $1,000, anywhere in that range. But I would say that you're looking at somewhere between $900 and $1,700 for a residential closing. And if you are the seller, well, you don't pay any money up front. It comes out of the closing fees at the time of closing. So you hire the attorney. Most attorneys aren't going to ask for any money up front, and they get paid at the closing. When you are selling a house, it depends on the attorney. Sometimes they ask for money up front, and then it doesn't go through. They call it the HUD, or the HUD 1. It doesn't go through the HUD. So at the closing, there's no money that changes hands to the attorney because you've already paid them. So that's the answer to that one. Looks like we're about a half an hour in. Just want to check and see what other questions we have. Okay. So I think what we're going to do today is we're going to wrap up with one more question, and then I'm going to talk for a second about Thursday's Understanding the Law radio show, and I also want to encourage you guys to comment and let me know if this is something that you're interested in doing. I like to talk, but I don't want to do something that you guys don't see a value in, that you're not getting anything from. So really, your feedback's important. All right, so this is the last one we're going to do today. The question is, I filed a complaint pro se in New Jersey Superior Court and served the defendants. The time for the answer has expired. What is my next step? Well, we all know that pro se means without an attorney. So this gentleman has filed a complaint on his own without an attorney. What is his next step? Well, here's the answer. You need to file for a default judgment. Now, there are some courts, so for example, New Jersey's Special Civil Division, you automatically generate a default. The court automatically generates a default if the defendant hasn't answered within a particular period of time. You then have to enter that default and do something more with it, but the entry of the default is prepared and done by the court. This is a Superior Court case. It's different. The court does not generate an automatic dismissal notice or judgment notice, or default, I should say. You have to file a motion for a default judgment. You have to actively and affirmatively petition the court and say, here, I filed a complaint. It was served. Here's my proof of service. The defendants had to answer by August 1st. They didn't answer by August 1st. Now I'm seeking a default. And then you petition the court, and as long as your papers are in order, you'll get your default. And then, you, depending upon the state again, docket it with a particular state agency or entity, and then you can apply for a wage garnishment or a bank levy and try to get your money that way. So that's the next step. It's a default. You need to file for a default judgment. All right, so that is all we're going to do today. I'm going to save some of these questions for next time. I want to remind you guys that this Thursday at 10 a.m. Eastern Time, Understanding the Law Radio, we're going to be interviewing Stephen Mansfield. He is a New York Times best-selling author. He's written books like Mansfield's Manly Men, his new book about the search for God in Guinness. So we are very excited to have him on. We're going to talk to him on Thursday. We also had recently on Alan Fisher, Cobra Rhodes, and Alan's wife Carolyn, who are all world champion, world title holder arm wrestlers, and they were all stars of AMC's Game of Arms last season. So I believe that was episode 71 if you want to take a look and download that. Tune in Thursday, and if you have questions for Steven, you can call in. The call-in number is, let me just grab it, it's 347-855-8831. That goes right to the switchboard for Thursday's show. Also, make sure you subscribe to our YouTube channel. You're going to get, obviously, content like this and notifications of live events, but you're also going to get access to all of our new videos as we put them up. We try to do as many informational and instructional videos as possible per year. We've received a lot of positive feedback, and I appreciate that, so thank you. Also, follow us on social media. Twitter, I told you, at PJL Law. Facebook, Google+. We're all over the place. Make sure that you interact with us, ask your questions. The other thing I want to tell you about real quick is if you go over to the iTunes store, available for iTunes and the iPad, is a free app. Just search the name of the firm, Law Offices of Peter Lamont, and download the free app. It's completely free. No in-app purchases. No, nothing. It's free. And why do you want it? Well, because you can ask your legal questions to me directly through your iPhone or iPad. There's a button on there that says Ask a Question, and you just ask your question right through the phone. It's going to come to an attorney in my office, either myself or one of the other attorneys. We're going to answer the question for you and email you back directly. So it's something that you should do. Everybody has a time in their life where they've got a legal question and they don't always either have the money or want to pay the money to have a lawyer answer the question. So we're doing it for you for free. So I'd like to thank you for watching this, for downloading it later, for viewing it later. Don't forget, leave questions in the comments section down below this video. Let me know what other legal issues you'd like to discuss, what questions you have. You can also email me directly. I'm going to give that email address to you right now. It's plamont, P-L-A-M-O-N-T, at peterlamontesq.com. And if you've got an issue that you'd like me to address on the air, but you feel more comfortable doing it through email, then please do that. And then we're going to continue doing this, assuming we continue to get positive feedback, and we'll schedule the next live event in the next few weeks. I have a trial coming up, so we're going to take a break from the live events, but put in your feedback. We'll see. Maybe I can manage to do one next week, and just keep your questions coming. All right, I hope that you found this helpful. Again, my name is Peter Lamont. Thanks for watching. Thanks for following us around the internet. And remember that there's power in understanding the law, and that's why we do this, to give you that power so you understand the law and your legal rights. So thanks for joining me today, and I look forward to seeing you next time.